Here's a quick disclaimer for the presentation you're about to watch with Robert Finlay with Wright, Finlay, and Zach. This presentation provides general industry information on the subject matters covered as of the date of presentation and is not intended to be legal, regulatory, or strategic advice for a specific financial institution. The opinions of the panelists are their own and not those of their respective companies. Questions regarding how this information applies to your financial institution should be directed towards your legal counsel. Now let's jump right on into it.
Yep. My name's Brad Laddusaw, president of the California Mortgage Association. I'm here with Robert Finlay today with Wright, Finlay, and Zach. We've been rolling out updates on AB130 and the implications it's already having on the lending industry. And we felt it was important to give an update to the industry in its entirety on what has happened since it's been enacted into law as a budget trailer bill earlier this year. Also, what the industry is doing about it, CMA and a few other trade associations, as well as the law firms that are representing us. So, Robert Finlay, would you mind giving everyone just a quick recap of AB 130 and what's it about?
Yeah, I'd be happy to, Brad. First off, thanks for having me. I appreciate it. And I'm glad we're going to get the information out on AB 130 because I'm finding that still people don't know much about it and they're already, or they're reaching out now trying to figure out what to do. And whereas a lot of people have been working on this for several months. So um, there's two main aspects to AB 130. First is it creates this list of the 6 deadly servicing sins, as I call them. And these 6 things, which I'll list real quick, they were not unlawful June 30th or June 27th, but on July 1st, they became unlawful practices. And what those are, simplistically, is one is if you fail to provide written communication with your borrower for a 3-year period. And what the law was targeting there, and this was actually the main focus of the law, although it went much further than that, targeting those what they call zombie seconds, which I prefer to call aged seconds, that maybe were charged off in 2010 after the mortgage meltdown, and no one had been communicating with the borrower for several years on those. The legislature, they naively believed that the borrowers didn't hear from anybody whatsoever for a decade plus, and then suddenly got a notice of default, which we litigate these cases all the time on behalf of the lenders, and that's rarely the case, or it's never been the case actually. But that was their target. So that's unlawful practice number one: failure to provide written communication with your borrower for a 3-year period, and that's not the last 3 years. That's any 3-year period. And then number 2 and 3 I'll kind of combine, which are that if you fail to send the required servicing or ownership transfer notices that are required by TILA and RESPA, assuming your loan is covered by those, you have to send those servicing transfer, hello, goodbye letters, ownership transfer, hello, goodbye letters. So that's the first 3. Number 4, and I may not be in the order of the statute here, but number 4 off the top of my head is that you foreclose or threaten to foreclose after the statute of limitations has run on your loan. That one I haven't seen too many issues with, so I'm not as concerned with. Number 5 is that you foreclose or threaten to foreclose after the servicer or prior servicer sent a form indicating that the loan had been written off or discharged, which would include a 1099-C. So case law holds that sending a borrower a 1099-C does not discharge your debt and does not prevent you from collecting on your deed of trust. However, now California has made it an unlawful practice to start foreclosure after sending one of those notices. Where I see issues there is the industry uses the term charged off when a loan becomes stale and they're not going to collect on it anymore. I'm sure there's going to be litigation over the statute which says discharged or written off. So I think there'll be litigation trying to argue that discharge is the same as, charged off is the same as discharge and so forth. And then the last one is the failure to send a required monthly mortgage statement. So if you're required to send a monthly mortgage statement and you didn't do it, that's one of the deadly sins. So those are 6 unlawful practices. And that's the first kind of group or issue that I want to point out about AB130. The second one is that if you have a second lien, before you can foreclose or threaten to foreclose, you have to record the certification. And the certification has to be recorded simultaneously with your notice of default. And the certification must be signed under penalty of perjury, and it must attest that the servicer, which is defined as you, the current servicer, and every other servicer that's ever touched this loan, that the servicer did not commit any of the unlawful practices that I just mentioned. So if you've taken over a loan from someone else, from a servicing standpoint, you may not want to certify under penalty of perjury that the other servicer did everything that they were required to do. That's a scary thing to sign off on. So those are the two main things: the 6 deadly servicing sins, and then the certification.
And then a lot of times when we have a legislation or something that comes through that can impact us as lenders, there's a difference whether it's a consumer loan or a business purpose loan or an investment type strategy loan. In this instance, is that the case, or is it just a catch-all? Would you mind jumping into that a little bit?
Yeah, great question. So this loan or this law applies to all loans that are secured by residential property. And it's not limited to business purpose loans. It's not limited to consumer loans. It doesn't differentiate. But also, it doesn't have that 1 to 4 cap. A lot of our laws differentiate between single family 1 to 4 versus 5 and over. This one here applies to any loan that's in a subordinate position that is secured by residential property. So it could apply to a consumer single family loan, a business purpose loan on a triplex, or a commercial loan on 30 an apartment complex with 30 units.
So I mean, we just funded a loan, first position, not a second. It was a mixed use. So we had a retail component and 2 residential units as well. So even that asset would get grouped in there since there are 2 residential components to it.
I definitely think that's a fair reading of the statute because there's a residential component. Of course, if someone raised that argument in court, I would argue that no, because that was not the intent of the statute. But I could see that as a possible reading of the statute. Yes, that apply to mixed use as well. And one thing to point out, Brad, is this applies. I said second liens. It's actually you define it as subordinate liens, and so it could be a second, it could be a third. And the way they define subordinate lien is if there's another deed of trust on title, when your deed of trust records, you're subordinate.
And I'm going to do my level best not to say any curse words during this interview, because the way you explain that, and this is going to be free flowing. We're going to be jumping around a little bit because there's a lot to cover, and we'll make sure to get through it all. In that instance, we have someone acquired let's say a building, and the lender did a construction loan for them, and it's a residential, it's an SFR. They finished the property. Now that loan has come mature. Another lender is going to come in and say, hey, we're going to do a 2-year bridge loan for you so you could finish the project and then hold it as an income producing property. So still business purpose loan. At the time of that refinance being funded and closed, that reconveyance has not been recorded yet on that initial loan. So am I going down this rabbit hole as being a little too paranoid, or is that an argument someone could potentially make that even though I was insured, recorded as a first position lien holder or deed of trust by title, technically that other deed of trust was still recorded?
Yeah, you are going down a rabbit hole, but you are not alone. That is a very deep and heavily occupied rabbit hole. So that is a concern, and we've been talking to many of our clients about that and some of the largest servicers across the country. So a technical reading of the statute, yes. That if like under your example or the one I use, which is I refinance my house tomorrow, the new loan goes on tomorrow, and the existing lender has 30 days to reconvey the deed of trust. So the new loan that goes on is intended to be in a first position, paid off the first lien, but under this definition, arguably as a subordinate lien. So I see the technical reading. However, having been actively involved in the legislative process for the CMA and for other organizations, that was not the intent of the legislature at all. I've looked at the legislative history of the statute. That was not the intent at all. They were really just trying to target these age seconds. So I feel good that we should be able to prevail on that issue if someone raises it down the road, and someone will raise it. I have clients where someone's already raising it, that this first lien is really a subordinate lien under the definition in AB130. So I can't guarantee you're going to win on it, especially at the trial court level, but I do think at the end of the day, we should be able to prevail on that, and it should be appellate court level.
Yeah, and that's the challenge. It's like, all right, you're looking at, and we talk about this all the time. If you're writing a loan, and depending on what that loan amount size is and the protective equity you have, I mean, the amount of legal fees to battle this is going to potentially eat at your protective equity and any stall tactic. And it's now if you're in a junior position, we're going to get into some challenges your clients are having in a little bit. So I don't want to jump too far ahead. What does it take? You're talking about subordinate loans, and that's the intent of this law. Subordinate lien holders, lenders, second, third, fourth. Hope you're not doing fourths. But it's recorded junior to another deed of trust or any other lien that is on the property.
Deed of
Because
trust.
my concern of mechanics liens or substandards or liens that the city has on the property, does that force you into a junior lien holder position or subordinate?
It's going to have to be a deed of trust.
Okay, to another deed of trust. It's pretty clear on that. And then let's jump into process a little bit. We'll discuss some of the challenges with the certification that loan servicers will need to sign in a couple minutes here. But when I was, and I am not an attorney, clearly, but when I was reading the law, I was a little shocked that the words they chose to use is that the borrower just needs to believe that something was done unlawful or incorrectly. Was I reading that correctly? And how does that process what does that mean?
Yeah. So it's interesting because while if a borrower sues, the borrower is going to be the plaintiff, and the burden is on the plaintiff to establish their case. However, the statute, I think, unintentionally shifts that burden onto the servicer. So the servicer's got to decide whether any of the 6 deadly servicing sins were committed. Let's say they look at it and they decided that no, I think we're good. I see all the statements, I see all the transfer notices, or maybe even better yet, I originated this loan and I've been servicing it the entire time. So a borrower can then file suit and say no, it wasn't done, and it's going to be up to you, the servicer, to prove that you didn't commit an unlawful practice. And the way I read one of the remedies that the borrower has is that he can go in and get a TRO and a restraining order to stop you from foreclosing if they file a lawsuit. Well, the way it says, the court shall grant a TRO. So the way I look at it is that it's almost like it's mandatory for the court to grant a TRO just because the borrower says you committed one of these, 6 deadly servicing sins, and that goes against decades and if not hundreds of years of case law and statutory law that normally when a temporary restraining order or an injunction is issued, the borrower has to hop through certain hoops, and one of those hoops is that they need to show that they're more likely than not going to prevail in their litigation. But this statute doesn't seem to require that. It seems to make it almost mandatory to the court that if the borrower says you committed one of these sins, then you're enjoined. Now, that said, I think there'll be some judges who will rely on that shall language and they'll grant TROs blindly. I think there'll be other judges that it's been ingrained and then the borrower must show merits of their case to get an injunction. And I think there'll be some judges that will go ahead and do that. Will require the borrower to show that we did something wrong, or at least require us to show that no, we did send all the statements. We didn't have any periods of no communication for 3 years and so forth. So we'll see how that's going to play out. It's going to differ from judge to judge. But that's an interest. It's a problematic point that you bring up.
Yeah, and then let's assume a judge hands out those TROs just like insurance agents hand out EOIs. What does that do potentially to the timing? Because this is so still in its infancy, and I'm of the belief it's going to be slow, 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 then all at once. And we've seen courts get packed with certain types of cases where things get delayed, and there's only so many man hours in a day. If they're just issuing these TROs, like, what does that do to the timing of that foreclosure process? And do we even have an understanding or idea of how long that process might take to see that case?
So great question. And, I kind of think about it
And
in
I
terms
didn't
of,
give you this ahead of time. This is just pressing at me. So
no worries. So I kind of think about like similar to the Homeowner Bill of Rights litigation, Homeowner Bill of Rights that went into effect in 2013. It took years and years and years for the cases to work their way through the system before we started having appellate decisions interpreting the statute. In fact, we're still getting appellate decisions interpreting the 2013 Homeowner Bill of Rights. So I think that's going to be the same thing here. I mean, think about it. We already have lawsuits. We have lots of lawsuits over this AB130. And by the way, you'll hear it called AB130, but it's actually been that was the bill. It's been codified into Civil Code section 2924.13. So we have a lot of litigation already over 2924.13. Those cases, assuming we don't settle, it's, we're probably going to have a judgment one way or the other in midway through 2027. Or sorry, midway through 2026. Okay. Maybe late 2026. Then if someone has to file an appeal, to go up an appeal, we're looking at mid to late 2028. I'm sorry, I'm jumping ahead. Mid to late 2027 before there's a decision interpreting it. And the decision is only going to interpret the narrow issue that's before the court. There'll be still other things that are left to interpretation. So in federal court, we'll get some non-binding decisions a little quicker, which is good. In fact, we already have one decision that came down, again, non-binding, but that said that the statute should not be read to be retroactive. And the way I interpreted that decision is that if you committed one of those 6 deadly sins prior to July 1st, that they would not be an unlawful practice and not be a grounds for litigation. Courts have the option of following that logic. I think some will, but we won't have an appellate decision for many, many months and perhaps many years.
So 2 points that you bring up there. I mean, mid to late 2027, and on a potential resolution, if it's going down that full all the way down the line, like you mentioned. What doesn't we're subordinate lien holders. So what happens to the first? Have they just paid off that first during this time? Because there's nothing that stops the first, right?
Yeah, that's the most pressing problem for a lot of my clients right now. And so the seconds always, when you make a second, that your subjects will be wiped out by the first. First foreclosures, you're gone. You know that. That's a risk. So what most seconds do is they make sure their maturity date, their loan matures before the first. If they both go into default, they start their foreclosure sooner, and they record their NOD first. That way, they're able to foreclose first before the first lien holder does, the senior lien holder. And by putting themselves in that position, they can then foreclose, take back title, or maybe someone else takes title and pays you off, which is even better. But they can take back title. At that point, they're the property owner. They can reinstate the first lien while they try to sell. They can pay off the first lien while they want to sell. AB 130 creates a big problem for those junior lien holders. Because first off, number one is your NOD may have recorded prior to July 1st, but because the certification must be recorded with your NOD, and you didn't know that till July 1st, a lot of second lien holders are having to rescind their NOD, record a new one with the certification. Now they're behind the first foreclosure, and the first is going to foreclose before that. So they have a couple options. They have the traditional options, reinstate or pay off the first. The risk with that is, even after you pay off that first, you're still a subordinate lien. You still have to record that certification. So if you have problems, if you have, if you're concerned about those unlawful practices, or your servicer won't sign the certification, which is a real issue these days, you may never be able to foreclose. And now you're, instead of just being out your $200,000 second, you're out $1 million first that you just paid off. And if you don't pay it off and you reinstate it, well, more monthly statements are going to come due every month. So those are the old options. Those are dangerous because you may never, because of AB130, you might not be able to foreclose. The other options are you could try to buy the first lien. Not all first liens are for sale, but some are. You could go ahead and buy that first lien. And that's different than paying it off, because if you buy it, you are now that you step into the shoes of the first lien holder. You have the first lien, and you could go ahead and foreclose on that first lien. So that gives you an option. You can also show up at the foreclosure sale and bid. So again, under my example, the first is $1 million. You're owed $200,000. Let's say the property is $2 million. There's plenty of equity. You could show up at that foreclosure sale and bid. You're gonna have to bring cash and bid up to, let's say, $1.2 million. If you're the successful purchaser at $1.2 million, $1 million is going to go pay off that first. $200,000 is what we call excess proceeds, and is going to go on down the line to the next lien holder, which would be you, assuming you're the second lien holder, and you're going to get your $200,000 back. So now you're out of pocket $1 million, and you own a property that's worth $2 million. So you're going to be covered. You're going to be made whole. So that is an option. And if you're not the successful bidder and somebody else comes along and buys it for 1.3 versus paid off, you're paid off. You're happy. So that's definitely an option. Although for buying a first lien or bidding at the foreclosure sale, I absolutely 100% recommend talk to an attorney first. If you have in-house counsel, great, talk to your in-house counsel. If you have outside counsel, whoever it is, doesn't have to be me, just talk to an attorney, because there's definitely risks associated with taking those either approach, and you want to make sure you know what you're doing.
It's a good point. I should have thrown out that disclaimer on the onset. You're our attorney, but everyone listening in, you are not their legal representation. So this should not be taken as legal advice. They should consult their own legal before taking any course of action based on some of the topics we are discussing here today.
Absolutely.
So
Thank you,
I
Brad.
want to make sure going that. And if I was good at editing this, I would shift it all the way to the front, but I'm not. So that is going to be smack dab in the middle. But we will make sure to highlight that. On the challenge, also the challenge I see with that, I would make a strong argument that even though a lot of junior lien holders know the risks they're taking, they don't have the liquidity to pay off a $500, $700, $2 million first, even though they should be repping and saying, yes, we understand and we can do that. Maybe 1 or 2 loans, but hey, if they have 5 junior loans, I think there's very few investors that could come in with that type of liquidity to cure or buy those first in short order. So it's I do see some big challenges with that, and I'm sure that's something you guys are probably looking at firsthand.
Absolutely. It's
Um,
yeah.
and then that recent case you're talking or ruling about that saying this statute shouldn't or can't be applied retroactively. That Do you see that if that were to start picking up steam, is there anything that case can be used as, let's say, ammunition? Again, not legal advice for anyone currently going through a situation or a loan servicer, because I want to get into some of the challenges that loan servicers are having signing these certifications. And that
Yeah. So,
retroactive line makes a very big difference. Uh,
yeah. So, I'll talk about from a legal standpoint and a practical standpoint. So I think, so generally speaking, when new statutes go into effect, they are not retroactive unless specifically designated as such. This was not designated as retroactive. So I think there's a very, very good argument that those so-called unlawful practices, if they occurred prior to July 1st, that the statute's not retroactive, and what was legal on June 30th is not suddenly an unlawful practice after the fact. I think we're going to win on that argument. I think regardless of that recent case that came down, or the decision in federal court, we were already planning to make that argument, and I think it's a good argument. I think we're ultimately going to win on that argument. Of course, I can't make guarantees, and we may lose several times at the trial court level before we win on the appeal, but I think we will win on that. Uh, that said, I don't know if I was designing my servicing procedures, if I would rely on the fact that, Robert Finlay on a podcast with Brad Laddusaw said after a massive disclaimer that, we're going to win on that. He feels that he's going to win on that issue. I don't know if I'd take the risk necessarily. If I can comply with the certification, I would go ahead and comply with the certification and assume that my unlawful practice from before is actionable, and be ready to defend it if need be.
And I think the big risk there, it's from a loan servicer's perspective. And I talk to a lot of them. Um, they're certifying all previous actions of previous loan servicers. Some of them may not even still be in business for probably doing things that were unlawful on that. And now they're on the hook to certify that they did everything correctly. And then I'm even simplifying it even more. Even if, let's say, I funded a loan myself, I serviced the first 3 payments, and then I sold off and fractionalized the loan thereafter and transferred loan servicing. Do you see loan servicers not accepting those junior position loans or subordinate loans to service, or are they kind of taking those on? I see them kind of putting their foot down, say, "Hey, even though it was only 2 or 3 payments, I can't certify to what you did."
Yeah. So, right now, there are some servicers who are taking the position that if unless I've serviced this loan the entire time, I am not going to sign a certification under penalty of perjury that everything that all the prior servicers on this loan did everything right and didn't commit an unlawful practice. Even if I have the monthly statements in my file, even if I have the transfer notices, some are just flat out saying, no, I will not take that risk. Others are looking at specific situations and say, okay, do I have my transfer notice? Yes. Do I have all the statements? Yes. How do I feel about the prior servicer, Brad? And then do I feel that he sent those 3 statements? He says he did. I trust him. Okay, I'll sign the certification. But some are refusing to sign it. So what does that leave? What options does that leave for the investor? Well, the investor can go find another servicer. Fine. You're not going to play ball with me, servicer. I'm going to go to a different servicer. Problem is that new servicer is going to be really, really wary because they're going to, why your loan's in default, why you transfer servicing, you want me to sign the certification, but your prior servicer wouldn't? Well, that scares me. Why wouldn't they sign it? I respect that prior servicer. If they're not going to sign it, why would I sign it now? So you're going to have that problem. The other option for the investor is to go ahead and basically self-service the loan and test that everything was done properly and there was no unlawful practices. Well, now you're relying 100% on your servicer. Do I trust my servicer? Did everything right? Why didn't they want to sign it? They were nervous. Maybe I should be nervous. So there's some concerns there. And then there's also a question of if you're the investor on the loan, do you have to basically transfer servicing to yourself? Because do you meet the definition of a mortgage servicer under the code? It doesn't really give us one under the code. So I would argue that maybe that an investor could be deemed the mortgage servicer, but the easier way would just be to transfer servicing. Just make sure you send out the transfer servicing notice if it's required.
Yeah, and I talked to some lenders that still are just hearing about this, which they need to know the potential implications of or just the ability to enforce their junior position loan and what that looks like. And if they've transferred loan servicing, they need to call their loan servicer because some of these loan servicers are already servicing seconds that have been transferred since this is retroactively applied. And I would say one of the first phone calls after listening to this would be to call your loan servicer and go over your entire portfolio and ask a simple question. Would you be willing to sign a certification if this went into default? Ideally, the portfolio is performing well and that there's no defaults on any of those or any potentially coming down the pipe. But that's a very important question to ask, is if you find out when it's too late, it's kind of too late there.
Yeah. And one thing I'll add about the certification is there's two boxes you can check. One is there was no unlawful practices. The other box is that there were unlawful practices, and here they are. So you have to identify what they are. Okay. So, like for instance, if you have a loan where you sent, for a fact that 24 out of 25 statements were sent, and one statement was missed. And let's say it was the first statement or the second statement, so it was early. So you got a track record now, 2 years of statements. You could sign the certification, check that box, acknowledge that there was an unlawful practice, and say that the March 2023 statement was not sent. Now, and that will allow you to proceed forward with foreclosure. One concern there, though, is you've now admitted to an unlawful practice. You've admitted to breaking the law. And could you be sued for that unlawful practice? I would again go back to the fact the law is not retroactive, and that and then also that you've acknowledged it, and it's no harm, no foul. Borrower's not damaged by that alleged or that admitted unlawful practice. So there's arguments to be made why you wouldn't suffer exposure from that, but someone can still sue you. And they've said you've now admitted to an unlawful practice, and they could turn that into a 17200 action, which is our unlawful unfair business practices statute in California. So I would, like I mentioned before you admit to committing an unlawful practice in a recorded document, I would talk to your counsel first.
Yeah, and that's on the loan servicer as well. So, I mean, that's tough, because if you're certifying to someone else, you say, "Hey, I believe they did an unlawful act," or "Hey, we missed one. We've caught it. It was a slip on our procedures." And if now your investor is at risk of loss, I just see it being a very slippery slope across the board from a loan servicer's perspective on shots getting fired at from all directions. So that I see why they wouldn't potentially sign that cert on that from if they're doing it from day one, because it's not solely from the borrower.
There are several clients that I have and people that I've talked to that they're paralyzed right now. They can't do anything. And one of the questions they often ask me, and if I'm jumping ahead, this may be on your list, but why don't I just go ahead and go with a judicial foreclosure? And there are some servicers and investors are going to go that route. So if you go judicial, all of the 6 deadly sins can still be raised as an affirmative defense to your judicial foreclosure. That's all it says. Does that mean you can't foreclose? Not exactly clear. It just says it can be raised as an affirmative defense to judicial foreclosure. So judicial foreclosure may not be an effective solution. What it does do, though, is it gets you out of having to sign the certification. So that is the nice part. You don't if you go judicial, you don't have to sign the certification. Now, again, the 6 deadly servicing sins can still be raised as a defense, and you're now in a judicial foreclosure, which, best case scenario, if they don't even answer, it might be, 6 to 9 months to get a default and get a sheriff's sale. And then if they file an answer, you're looking for a year to 2 years, and it's going to cost you a lot more than a non-judicial foreclosure. So it's not the best option. And then if we all go judicial, what's that going to do to our court system? It's good. The courts aren't built for a massive amount of judicial foreclosures like, the East Coast, where you have a lot of judicial foreclosure states, and they have special courts that deal with judicial foreclosures. We don't have that. This is going to get lumped in with every other lawsuit, and it's going to inundate and overwhelm our court system if everybody goes judicial, which is possible.
Yeah. And unfortunately on this, whether you self-service your loans or you have a third-party loan servicing doing it, it is a very low bar for that borrower to say, "I believe an unlawful act was committed." So all but adds, and nothing's guaranteed in life. A couple things, but for the most part, nothing's guaranteed. But there's a high probability that if you're foreclosing in a junior position lien holder, that is going to be petitioned to the court to
And
delay.
and I'd like to believe that most borrowers are honest people and don't lie, and most are. Unfortunately, the only majority of the matters I see are in litigation, And in my experience of doing this 30 plus years, borrowers will say and do anything that benefits them in their litigation, whether it's true or not. So yeah, I think you're going to see a lot of borrowers stretching the truth to try to stay in the home for as long as possible.
Yeah, and I mean, we could go down scenarios till we're blue in the face, but if can you share one or two live situations that you or your clients are currently facing due to this AB 130?
Yeah, I mean, it's kind of everything we've been talking about. It's those junior lien holders whose servicer is unwilling to sign the certification, even though we have no belief whatsoever that there was an unlawful practice committed. This loan was originated in less than 3 years, so you have to worry about the communication factor. It transfers servicing maybe once early on, like in your example, but the servicer won't sign the certification. I'm getting calls. It feels like every day from investors saying my servicer won't sign the certification, and I get it. I get why the servicer, it's their business. Why would they take on that exposure and liability signing a certification under penalty of perjury? And keep in mind, signing something under penalty of perjury that's wrong isn't just civil liability, it's potential criminal liability. So a lot of servicers say, hey, I'm not going to take that risk for you. And that is the biggest problem I'm experiencing with my clients. But it's one thing that's really interesting, talking about rabbit holes, Brad, that I've learned from this is, this bill was intended to hit these age seconds. And even though we warned the author of the bill over and over again as to the ridiculous scope of what they had proposed, and they went ahead and submitted it anyway, we're learning even beyond what we initially thought, the scope of the impact of this bill. So, for instance, HUD partial claims. So if you have a first lien insured by FHA, they have a program that, let's say you're $30,000 behind, you can't pay it. Instead of putting that on the back end of the loan that accumulates interest, they put it onto a second lien, which is the HUD it's partial lien, but it's a lien. Well, that's a second lien on the property. Generally speaking, I'm not aware that there's monthly statements sent out. I'm not aware that there's communication over the loan being sent out because it's just sitting there waiting until the property's sold. And so that loan may have issues down the road. SBA, when you take, if my law firm takes out a business loan to buy a building, the lender is going to demand a second on my home. But that second, often no one's collecting on it. It's just sitting there because the focus is the business loan. And I'm making payments on a monthly basis. So there's no reason to communicate with me on that second lien. Well, now you could have AB 130 issues on your SBA loan. HECM, reverse mortgages, which are kind of like it's a reverse mortgage, but it's kind of like a home equity line of credit in a way. When you do a HECM, those are first recorded, and then there's a second recorded on behalf of HUD. That second on behalf of HUD, I'm not aware of any collection activity that's being done on it. Everything's being done on the first. So there may be issues there. There are cities that have affordable housing or down payment assistant loans that they offer for people that are of lower income. Well, those are second liens. I would guess that many of those cities don't even know about this law. Many of these cities don't record or don't communicate on this loan because it's just sitting there waiting to be paid off when the borrower sells the house. That could be a problem. I learned that Kaiser gives out loans to some of their doctors and other staff to help them for the first time purchase of homes. It's no or low interest and just sits there until they sell the property. Well, I don't think there's any collection activity going on there. Those are affected by it. So there's so many groups of second liens that are affected by this law that the legislature had no idea, nor do they want to take the time to even look into this law to figure out the potential impact.
butterfly effect. Just kind of just keeps on going and going. And then even on you highlighted this earlier this year, some loan docs require, the way they're drafted, require you to notify your borrower that, hey, we're going to be taking, it's a default notice letter effectively. And the way this statute is written, you cannot provide them that notice because that's threatening foreclosure, correct?
Yeah, so some, I think it's a Fannie Freddie standard deed of trust, paragraph 22, I think it is, but it says that you got to send out this notice of intent to foreclose, and the industry calls it kind of the NOI, and that must go out, and it's a notice of intent to foreclose. But the way that the statute's written regarding the certification is you can't foreclose without recording that certification. Fine. But you also can't threaten to foreclose until recording the certification. And the certification is recorded with the notice of default. So what that means is you can't threaten to foreclose until you actually start foreclosing. You can't threaten to foreclose until you record your NOD. So servicers need to do a couple things. They need to clean up or I would recommend that they clean up their collection practices, their demand letters, make sure you're not threatened to foreclose, your training of your collection staff to make sure they're not threatening to foreclose. But then you still have that problem with that NOI letter, notice of intent to foreclose. You could soften it a little bit, but at the end of the day, it still could be interpreted as a threat to foreclose. So what does someone do? I think you have a contractual clause, you have to honor it. And the whole purpose of that notice of intent to foreclose is to educate the borrower on the risks associated with not making their payments. And so they understand that the foreclosure is an option. So they understand that there's the options to avoid foreclosure. So I would talk to an attorney and balance the risk of sending that letter and the consequences of not sending it, because you can't foreclose without sending that letter if that's what your deed of trust says.
Yeah, and it's not required to have that notice of intent on a business purpose loan. It's just
No,
some docs have it. It's just
absolutely not. Yes, exactly. Which some people use Freddie Fannie loan docs for their business purpose loans, which we always recommend not to do that, because it, even though it doesn't change the nature of the loan into a consumer loan, it definitely can lend someone to argue that it was a consumer loan. And I thought it was consumer. Look, you use the Freddie Fannie form. So you don't have to use it, but and I wouldn't use it, not just for this particular reason that we're talking about.
Yeah, especially if you forget to attach that rider, because they definitely have an occupancy clause in that deed of trust.
Yeah.
So enough of that. This is clearly a mess. We knew it was a mess, and we have Mike Below, CMA's lobbyist up in Sacramento, that has been working nonstop since this was on the radar earlier this year as part of Lobby Day. This was part of SB 681 prior to, so we were up there, 18 different legislators and their staff trying to educate them on the potential impact this bill would have. It snuck in literally at the finish line. I think we had 2 days notice effective when we found out that it was going to be part of this now AB 130 as a budget trailer bill. So what's the industry doing right now? I know CMA is heavily involved, your law firm, book alter team, but would you mind sharing the actions that the industry has taken, CMA and a couple other trade associations, and then jump into a little bit more on what industry participants can do to help?
Yeah, happy to. So our law firm, Wright, Finlay, and Zach, along with the Buckhalter firm, have filed a lawsuit against the state of California to have AB 130, or actually 2924.13, deemed unconstitutional. We're challenging it because it's a violation of the Contracts Clause in the U.S. Constitution. It's an unlawful taking, so it violates a due process, and it violates the Supremacy Clause because it conflicts with federal law in certain areas. Lawsuit's been filed. We recently met and conferred with the Attorney General's office about the merits of the lawsuit. They don't think it has merit. Of course, we do. We also asked them if they would voluntarily stipulate to a preliminary injunction so that we could keep the law, keep the status quo while we litigate this. They unfortunately said no. So we will be filing a motion for a preliminary injunction. We're working on it right now. And this is the big one, because if the preliminary injunction is granted, it stays the enforcement and applicability of this law throughout the duration of the lawsuit. And the lawsuit could take 1 year to 2 years. So if it that would negate the effect of the law, would help a lot of people temporarily, and it would stay everything while we fight over it. If we win, obviously the law's gone forever. If we lose, the law may come back, but at least we've had 1 year to 2 years of reprieve, and during that time, we'll also be working on a legislative solution. Unfortunately, a legislative solution is not a realistic fix right now because the legislative session is done. The one for 2026 will go in March. If we propose a fix, which we will, then, and when I say we, as the CMA and other organizations, will prepare the fix. It'll go through the process. Even if it gets signed by the governor in September, October, it won't go into effect until January 1st, 2027, because it's not going to be deemed an emergency bill. So we're not going to, best case legislative fixes until beginning of 2027. But if we have an injunction in place, we can live till then. We can make it. That's fine. But it also gives us leverage to have a good legislative fix as opposed to just a minor one that doesn't really solve all the problems. So the preliminary injunction motion is big. If we lose it, we have to wait all that long time to do a legislative fix, and we won't have any leverage. So, I view this as the case, really, this preliminary injunction motion. So we're trying to line it up and trying to make it as strong as possible. Making the legal arguments is the easy part. What we need from people are their stories. And when I say stories, what I was talking about, those junior lien holders who can't foreclose, the junior lien holders who's about to get wiped out by a first lien holder or does get wiped out by a first lien holder. Those stories from the cities with their affordable or their down payment assistance programs, from Kaiser, from HUD, from anyone who is impacted by this. We need your stories, but we need you to step up and sign a declaration. Laying out how you're affected, how you're impacted. And unfortunately, we've had a lot of people have been too scared, too worried about raising their hand. They have financially, they've contributed, they're part of organizations who are participating, but some are just too scared to raise their hand. They're afraid that the AG is going to target them, that the DFPI is going to come after them, the DRE is going to come after them. It would be against the law for the AG or any of those organizations to retaliate because you raised your hand. That said, we understand that still is a risk. I'd like to believe that that's not going to happen. It's not the case. But either way, we're stuck with the law if we don't stand up and fight. So, so that's how people can help, Brad. They could reach out to me, and we could, tell me your story. We'll talk to you about what it looks like in a declaration, and hopefully you have a good story to tell, and we can, and that'll bolster our preliminary injunction motion such that we can get granted and it'll benefit everybody in the industry. So that's one way you can help. Number two is financial contributions. So the California Mortgage Association, was one of the plaintiffs, the Credit Union League is another plaintiff, the United Trustees Association, which is a plaintiff, all have stepped up and contributed substantial sums. In addition, the CMBA and the CBA have contributed financially as well. Several entities and individuals have contributed, but we're out of money. Filing a lawsuit, getting a preliminary injunction, we're out of money and we need more. So to the extent that people can reach out to me and want to contribute, that's great. Otherwise, you can reach out to your organization, any of those organizations I mentioned. If you tell them I want to contribute to the AB130 litigation specifically, they'll direct it specifically to us to continue the fight. So that's what you can do. Tell us your story, sign a declaration, contribute money, and this is pivotal. This is the most important part of the case in my mind.
And the preliminary injunction, that timing wise on that, when do you think we would have a decision one way or the other? Best case scenario, worst case scenario?
So I'd love to say we're going to file it next week, but we want to make it stronger. So goal is to file before Thanksgiving. We'll get a hearing most likely to early January, and we'll get a ruling immediately.
And I like to say, when we were talking earlier, this is For you basketball players out there, this is full court press time. It's one, educating the industry, sharing what's going on, and just bringing this new law to making everyone in the industry aware of it. A lot of the examples and scenarios we ran through, they started off as hypotheticals earlier this year when we first saw the language of this, and these hypotheticals are now playing out in reality because they were not conspiracy theories, they were not rabbit hole deep dives. This is just how it would play out, and it is. And unfortunately, we're in kind of a timing issue, I feel, where we have this law is so new, and the foreclosure process in California, it does take some time to go through the process. And then once you're at the finish line, it's boom, you're hit with this. Your loan servicer is not going to sign the certification, or the judge is getting petitioned. Now you're getting delayed out. You're behind. That first is foreclosing. So I do feel it's been kind of slow discussing hypotheticals. Now some of these hypotheticals are playing out in real time. And then we're going to, I don't want to say it, but this is how it will play out next. There will be some losses that will be hit because of this. And it's not going to be insulated to just the private lending industry. It will flow upstream to the institutional crowd just based on some of the situations and types of loans that are out there, Robert, that you ran through very quickly. And it doesn't take a lot of time. Well, once you understand the foreclosure process and you read the statute, you see the real risk that is can impact the industry. And I know we have a lot of lenders that are nationwide on the institutional crowd, and they have great loan products, and they do a lot more exposure in the state of California. So you East Coast lenders, you nationwide lenders that are starting to get more exposure in the state of California. This is a law that will negatively impact the industry, and it could potentially create some exposure in your portfolio, especially if you're servicing loans on behalf of others. So this is something that everyone needs to be aware of. I don't say that lightly. And it starts with picking up the phone, having a conversation, educating the industry, educating our legislators in a professional manner, because you can't go hostile at them. That would be a very easy way to get hung up on. And the financial support is very much needed. And then also real time cases that you're going through or scenarios that you see coming down. We need to hear those. We need to hear those stories. We need to share those stories. You don't need to necessarily jump on camera and talk about them, but we need to know what is happening real time because this is going to be slow, and then all at once. And then once the courts are jam packed, the timeline Robert laid out is the best case scenario. End of next year, mid 2027. Imagine it being 2028.
Yeah.
This is something that needs to be all hands on deck. So, Robert, I really appreciate your time. Anything else you want to add?
Yeah, one thing I'd say is you kind of alluded to it there that how this is going to impact the industry above and beyond current second lien holders. I've already talked to several lien holders or several investors who buy second liens. That's kind of their target. And they've said, we will not buy second liens in California. I've talked to some people who said, I will not fund second liens in California anymore. They're looking to do it in other states. Now that's going to cut into liquidity big time, and that's going to affect your industry. I mean, think right now, a lot of us were lucky enough to have 3% mortgages or less than 3% mortgages. We can't refi if we need money to put our kids into college, to do a remodel, to invest, to start a business, whatever it is. So we have to rely on second liens for medical bills, whatever it is. And if liquidity dries up and we can't get that money, what are we going to do? And also, I talked to someone last week that they're bidding on, or they were selling a pool of second liens, performing second liens, and the price dropped significantly because of this law.
Liquidity risk is a very real thing, and liquidity helps drive the markets and keep property values buoyant. We didn't even talk about seller carrybacks. All these
Oh yeah,
homeowners that sold their properties carried a junior seller carryback. They're not sending notices. They don't know what a notice is. Escrow and title probably drafted their promissory note and short form deed of trust. Um, that is the way this is written, and a lot of those are 5-year term loans
yeah.
that we see unenforceable just based on how this is written, and they're just forgiving all their equity. The lines of credits are HELOCs that people are able to tap into the equity of their home to put their kids in college, medical bills. I call it life, are just updating their home because they need to.
Or
That
Brad,
liquidity.
don't get ADU. The California legislature spent 5, 6 years trying to negating every law out there so that we can build ADUs in our backyard because they want us to build more units. And now we can't get financing for it. Most
And
ADUs are most loans for an ADU are going to be second liens, and you're not going to may not be able to get that loan. So
and
it's interesting that they want you to do the legislature wants you to do one thing, build ADUs, and but then they pass a law that totally puts a wrench into that. They just don't think through the potential impact, and we tried to explain it to them, but unfortunately they weren't listening.
Yeah, and it's just math. If I have X amount of my portfolio is potentially unenforceable, I'm either going to stop doing it, I'm going to reduce my leverage, or increase pricing.
Yeah,
Most likely number one, but reducing leverage and increasing pricing is going to make it like just getting another credit card. It's
yeah.
not going to be feasible to where it makes sense to the consumer. So I know we talked from a lender's perspective, but the liquidity concern will very much negatively impact the consumer
Oh,
that I
absolutely,
think the statute was trying to protect, and it's not. It is going to, I think, do the opposite
absolutely.
on that. And that's just,
Oh, yeah. And the
but
only thing I will add, though, Brad, one thing is, while this law makes it difficult to foreclose, uh, there's not the loan is still owed. So there's nothing preventing you from sending out a payoff statement, taking payoff funds, sending out a reinstatement figure, and letting people reinstate. So your loan is still out there right now. And if they want to sell the house, they're going to have to pay you off. They want to refinance, they're going to have to pay you off. That said, a lot of people don't have to do that, or they're not going to do that. So there is definitely the risk the loan is going to sit and sit and sit, which is very problematic.
and you have to address the first. And that's something I don't think has been talked about enough because there are lenders out there that are continuing to do seconds, and that's a business decision. It's a with the right underwriting, good parts, still a it doesn't prevent you. This law does not prevent you from writing the seconds. It's just in the event of default, what does that timeline look like, and what's happening to the first? And we just haven't had that high volume of those kind of go full circle yet, or come through. And that's when it's going to, I think, change. The tone will change drastically out there. But now all we could do is educate, share the ins and outs of this law, share real life examples as they're coming through, educate our legislators. Of course, I mean, I hate asking people for money, but contribute financially because this is something that affects the entire industry, not only the private lending, asset-based bridge, RTL, whatever you want to call it on a Tuesday. It also affects potentially the SBA, the Kaiser products that you're talking about, HELOCs, and those will take longer to kind of come, but eventually it will come full circle. And the liquidity concerns are a real thing that will negatively impact the consumer. So call it shaking hands and kissing babies. And sometimes it's updating on good news, but this is something that, hey, Robert, you aware of this bill? I know you do seconds. Something as simple as that. Just to say, hey, you may want to read up on it. Contact your loan servicer. Talk to your legal counsel. And if your legal counsel hasn't heard of it, get new legal counsel. I'm just kidding. Not advice, but it's all right, all right, Robert. Well, I truly appreciate your time, everything that you're doing for the industry, as well as the Buchalter team. You guys are stepping up in a big way, working a lot behind the scenes. I know the California Mortgage Association, the UTA, the Credit Union League, um,
Yes, CC.
as well, working behind the scenes. CMBA, the CBA, everyone is working. The amount of calls we've had with all these associations, really since May of this year, has been astounding. It is all hands on deck there. So, got any questions? You could email me directly, email Robert. It's something that we need to take very seriously as we head into the holiday season. So don't discuss this at the Thanksgiving dinner table. Save it for after.
All right, Brad. Well, thank you very much. I appreciate it. If anyone has any questions, they can always reach out to me. And if you have a story to tell and you're willing to raise your hand, please reach out to me quick, because we want to file this as quickly as possible to help the industry, but we want to make it as strong as possible.
Yeah, and we'll also drop a link in the comments of this video where you could go and donate. and it goes straight to fighting this lawsuit. So again, Mr. Finlay, thank you for your time, and I'm sure we'll be talking within the next day or two.
All right. Thanks, Brad. Take care. Thanks, everyone.